In real negotiations, progress isn't always smooth. Sometimes the parties stop moving forward. Nobody is willing to make the next concession. This moment is called a deadlock or an impasse. When a negotiation hits a deadlock, language becomes more important than ever. The wrong words can make the situation worse. The right words can open the door to resolution. Here's what you'll gain from today's lesson. First, you'll learn how to describe negotiation stalemates, situations where talks stop moving forward, using professional terms like fallback position, counterproposal, provisional agreement. Second, you'll practice advanced grammar that helps you sound persuasive under pressure. Emphatic modals like must have or can't possibly, and formal subjunctives for making proposals like we suggest that both parties consider. Third, you'll work with comparative structures to present alternatives clearly and strategically. For example, a better alternative would be, or this option is less risky than. Finally, you will strengthen your negotiation fluency with professional idioms, keep talks alive, leave room for maneuver, bridge the gap, and keep the dialogue alive. By the end of this session, you'll be able to break through deadlocks and guide negotiations toward resolution using professional, precise legal English. Let's begin with a story. Two companies are negotiating a licensing agreement. One company, the software developer, insists on a high royalty fee. The other company, a distributor, refuses to pay more than a fixed percentage. For hours, they repeat the same positions. The developer says, "We must protect the value of our product." The distributor says, "We can't possibly operate with those costs." The mediator notices the tensions rising. Both sides want a deal, but neither side will move. The room grows quiet. The negotiation has reached a stalemate. At this point, language becomes critical. The wrong words can harden the deadlock. The right words can open new possibilities. So let's reflect. Why did the negotiation stop? What options are available now? And if you were advising one of these parties in English, what could you say to break the deadlock without weakening your client's position? Keep these questions in mind as we move through today's lesson. We'll practice the vocabulary, grammar, and phrases professionals use to guide situations exactly like this. In a negotiation, a stalemate is very similar to a deadlock, but it's often used in a broader sense. A stalemate means no progress can be made because neither side is willing to move. For example, the salary talks ended in a stalemate after both parties refused to compromise. This word highlights the frozen nature of the discussion. It's not aggressive, it's descriptive and professional. Why is stalemate useful in negotiation English? Because it helps you diagnose the problem without blaming either side. It helps you to describe the situation to clients or colleagues in a neutral way. Helps you to prepare the ground for introducing alternatives. You'll hear typical collocations such as negotiations reached a stalemate, or breaking the stalemate, or prolonged stalemate in negotiation or arbitration. Avoid a stalemate through creative options. When you describe a negotiation as a stalemate, you're signaling that the new strategies are needed. And in this lesson, we will explore them and the language to provide them. In negotiations, paired lawyers, never come with only one demand. They prepare a fallback position. It's a weaker or secondary proposal they can offer if their main request is rejected. Imagine a labor negotiation. The union starts by demanding a 10% wage increase. The company refuses. But the union has a fallback position, a 5% raise plus shorter working hours. The fallback position allows the union to save face, keep negotiations alive, and still deliver value to its members. Why is this phrase so powerful? Because it shows strategy. When you explain to a client, don't worry, we have a fallback position if they reject our first offer, you demonstrate foresight and control. Collocations you'll hear in professional contexts are negotiate from a fallback position, or the fallback position was revealed during mediation. Without a fallback position, the talks collapsed. A fallback position doesn't mean weakness, it means preparation. Skilled negotiators always have one in reserve, ready to use if the deadlock cannot be broken with the main demand. In any negotiation, a flat no can kill the momentum. But a counterproposal keeps the discussion alive. Picture this. A real estate developer offers to sell a property for $2 million. The buyer says, that's too high. If the conversation ends there, the negotiation collapses. But instead, the buyer responds with a counterproposal. We can offer $1.6 million provided you include the adjacent parking lot. Suddenly, the discussion shifts. It's no longer rejection, it's movement. Why is this word so useful in legal English? Well, it's because it captures the idea of response plus creativity. You're not just refusing, you're building a bridge back to the other side. And in contracts, here's how you will hear it used in typical contexts. In contract talks, the counterproposal includes a longer payment plan. In mediation, counsel invited the claimant to submit a counterproposal. In corporate deals, after rejecting the merger terms, the board offered a counterproposal. Professional negotiators know every rejection should come with a counterproposal. It's how you keep the dialogue alive and avoid a dead end. In negotiations, nothing comes free. Almost every agreement involves a trade-off. Gaining one thing means giving up something else. Let's imagine a settlement conference. A plaintiff demands $500,000 in damages. The defendant says it's too high, but wants to avoid a long trial. The lawyers negotiate and agree on $350,000 plus a public apology. The trade-off, the plaintiff accepts less money, but they got closure faster and protect their reputation with an apology. The defendant pays less, but must make a public statement. This is the reality of negotiation. Progress comes through trade-offs. Here are some professional uses. The trade-off for lower rent was a longer lease term, or the parties recognized the trade-offs between cost and flexibility, or the mediator explained the trade-off, quicker settlement, but reduced compensation. Lawyers often explain this to clients who want everything. A skilled negotiator frames trade-offs as strategy, not weakness. You can say, this is not giving in, it's trading one risk for a greater benefit. Recognizing and communicating trade-offs clearly is one of the hallmarks of advanced negotiation in English. Sometimes in negotiation, the perfect deal isn't ready yet, but the parties don't want to walk away empty-handed. That's when they create a provisional agreement. Imagine two companies negotiating a joint venture. They cannot agree on the profit-sharing formula yet, but both sides want to start the project quickly. So they sign a provisional agreement. The companies will share initial costs equally. A final profit-sharing formula will be decided within 90 days. This keeps cooperation alive while buying time for details. Why is this important in legal English? Well, because it gives lawyers a tool to show flexibility without final commitment. Clients often fear being locked in. A provisional agreement says, we're moving forward, but only temporary. Common context you'll see. The provisional agreement allowed the merger talks to continue. Or, a provisional agreement was reached pending regulatory approval. Or, they entered into a provisional agreement to prevent disruption. In practice, provisional agreements are not always binding, but they are powerful tools to stop negotiations from collapsing. They show progress even if the final deal is still ahead. When negotiations stall, repeating the same offers won't help. What often breaks the deadlock is a creative option, a solution nobody had considered before. Picture this: a supplier and a retailer are stuck. The supplier insists on higher prices. The retailer says, "Impossible. We will go bankrupt." The mediator introduces a creative option. What if part of the payment is an advertising space instead of cash? Suddenly, both sides have something new to consider. The supplier gets visibility. The retailer avoids immediate cash strain. The negotiation moves again. Why is this phrase so powerful? Well, because it shows flexibility, problem solving, and strategic thinking. A lawyer who says, "Let's explore a creative option," signals professionalism without weakness. Common contexts that you'll hear are: the mediator encouraged both sides to consider creative options. Equity participation was proposed as a creative option to break the stalemate. Or creative options were introduced to save the failing talks. In high level negotiations, creative options can bridge the impossible gap, not by forcing concessions, but by reframing the entire deal. In international and corporate negotiations, it's common to capture progress even when the final contract isn't ready. One tool for this is a Memorandum of Understanding, or MOU. Imagine two multinational companies exploring a joint venture. They haven't settled the financial structure yet, but they agree on sharing research, protecting confidential information, and negotiating exclusively for 6 months. They record this in an MOU. The MOU is usually non binding, meaning it's not enforceable like a full contract, but it has real value. It builds trust, creates a framework, and prevents backtracking. Common professional uses are: the MOU reflects the parties' intent to cooperate. Also, a memorandum of understanding was signed pending a definitive agreement. Or, the tribunal considered whether the MOU created legal obligations. For lawyers, the phrase is critical. When advising clients, you must clarify whether an MOU is binding or not. In some jurisdictions, courts may interpret it differently depending on the wording. So, in legal English, MOU is more than just paperwork. It's a signal of intent, strategy, and structure in complex negotiations. In complex negotiations, it's often impossible to finalize every detail immediately. Instead, the parties may agree on a framework agreement, a broad contract that lays down the structure while leaving room for future specifics. For example, a government negotiates with several energy companies to supply renewable power. They cannot agree yet on the exact price per kilowatt, but they agree on principles: the volume of energy, environmental standards, and a timeline. They sign a framework agreement which says, "These are the rules. The details will be finalized in separate contracts later." So, you wonder why this phrase is so essential in legal English. Well, it's because it shows how negotiations evolve. First, there's the structure, then the details. Lawyers use it to manage expectations and prevent parties from walking away when they're not ready to sign a final deal. Professional contexts that you will see are: the framework agreement established principles of cooperation, or further agreements were executed under the framework agreement. Also, you will hear: the dispute concerned whether the framework agreement was legally binding. A framework agreement is like a skeleton, not the full body of the contract, but the bones that hold it together. It keeps momentum alive while leaving space for negotiation. In high stakes negotiations, not all preliminary documents are soft. Some are intentionally made binding, meaning the parties can be held to them in court. One example of this is a binding term sheet. Picture this: A startup is negotiating with venture capital investors. They need to lock in the valuation and the size of the investment quickly. The final shareholder agreement will take weeks to draft, so the parties sign a binding term sheet that states the company valuation is $5 million. The investors will contribute $2 million for a 40% stake. The deal must close within 60 days. Even if other details remain open, these core terms are locked. If one party tries to walk away, the other can enforce the term sheet in court. Why is this important in legal English? Well, because clients often confuse documents like MOUs, framework agreements, and term sheets. A lawyer must explain. An MOU is generally non-binding. A framework agreement, it sets principles with details to follow, while a binding term sheet is enforceable on agreed points. And professional context, while you hear this, is the binding term sheet secured the parties' obligations pending final documentation, or the dispute arose over whether the term sheet was binding or aspirational. Investors relied on the binding term sheet in enforcing the valuation. In negotiations, a binding term sheet is a powerful tool. It gives certainty on essentials while leaving space to finalize the rest. In high-level negotiations, tone is everything. Lawyers use emphatic modals to push their point without shouting. Imagine a corporate merger discussion. The buyer reviews the accounts and finds missing documents. Instead of saying, "You forgot," the lawyer frames it more diplomatically. "This must have been overlooked during the review." It sounds firm but not hostile. Now, suppose the seller proposes an unrealistic payment plan. The buyer's lawyer says that can't possibly be acceptable under the current law. The phrase "can't possibly" adds weight, showing the issue is not just an opinion, it's legally unacceptable. Finally, in mediation, a neutral party might reassure both sides. Their offer could well be the best option available. This phrase encourages flexibility without pressure. Why use emphatic modals? Because they let you show certainty, like "must have" or reject firmly but politely. "Can't possibly." It can encourage openness. "Could well." They give your English the authority of a lawyer and the tact of a negotiator, two skills you'll definitely need when breaking deadlocks. In negotiations, it's rarely effective to say simply, "That's wrong." Skilled lawyers reframe the discussion by comparing options. This is called comparative framing. Picture a commercial dispute over delivery times. One side demands immediate payment, the other side refuses. Instead of rejecting outright, the lawyer says, a better alternative would be to extend the deadline rather than reduce the fee. This shifts the focus. The lawyer isn't just saying no, they're offering a superior comparison. Now, think of a mediation about licensing rights. One option is litigation, the other is negotiation. The mediator says this option is less risky than proceeding to arbitration. By comparing risks, the mediator guides the parties towards settlement without ordering them. Why is this structure powerful? Because comparisons are persuasive. They show that your alternative is stronger, safer, or more reasonable. Keep negotiations constructive instead of confrontational. They help clients see trade-offs in a clear, logical way. Lawyers who master comparative framing can reject bad proposals while still keeping the conversation alive. Instead of dead ends, they open new paths forward. In advanced legal English, the formal subjunctive is used to frame proposals and recommendations in a professional, diplomatic way. It sounds neutral but authoritative, perfect for breaking deadlocks. Imagine a mediation where the talks are stuck. The mediator doesn't say, "You should suspend operations." That sounds too directive. Instead, they phrase it formally. We suggest that the parties agree to a temporary suspension. The wording is polite, but it carries weight. In another case, the lawyers disagree about continuing negotiations. One counsel frames it formally. It is essential that both sides consider the tax implications before rejecting this offer. This structure makes the proposal sound less like a personal opinion and more like a professional necessity. Even tribunals and arbitral panels use it. The tribunal recommends that negotiations resume within 30 days. Why do lawyers use the formal subjunctive? Well, it's because it lets you propose alternatives without sounding too aggressive, maintain neutrality in sensitive negotiations, and emphasize importance while keeping a professional tone. This structure is common in contracts, arbitration awards, and high level negotiations. For lawyers, it's a way to guide the discussion firmly, but without confrontation. In high level negotiations, parties need freedom to speak openly, without fear that their words will later be used against them in court. This is where the phrase, without prejudice discussions, comes in. Imagine two companies in a dispute. The defendant says in negotiation, we might be willing to pay $200,000. If the talks collapse, the claimant cannot run into court and say, see, they admitted liability. Why? Because it was said without prejudice. This phrase creates a safe zone. Parties can test options, explore compromises, or even admit weaknesses, knowing it won't harm them later if no deal is reached. Common contexts that you'll come across are these are without prejudice discussions, or the letter was marked without prejudice. Courts recognize the protection of without prejudice negotiations. For lawyers, the phrase is critical. It protects the negotiation process. It encourages frank dialogue and allows space for creativity without legal risk. Not every idea in negotiation is meant as a firm offer. Sometimes lawyers use exploratory proposals, suggestions designed to test the waters. Picture this. In a mediation about intellectual property rights, one company hints, what if we allowed a 5-year license instead of 10? This isn't a final position, it's an exploratory proposal, a way to see how the other side reacts. Why use this strategy? Because it reveals flexibility without showing weakness. If the other side rejects the idea, you can step back and say, hey, that was only exploratory. Let's consider other options. Professional contexts you'll hear are counsel emphasized that this was only an exploratory proposal, or exploratory proposals were exchanged to narrow the issues. Also, you'll hear the mediator asked each side to put forward exploratory proposals. This phrase is vital in legal English because it helps negotiators manage expectations. You are signaling we're open to ideas, but we're not committed yet. Exploratory proposals keep talks alive, open new doors, and they also soften rigid positions, which is exactly what's needed when facing a deadlock. In tough negotiations, there comes a point where one side says, this is as far as we go. That's the final offer, often called a best and final offer or BAFO. Imagine a labor dispute. The union wants a 7% wage increase. The employer refuses, but after several rounds of bargaining, put forward a document. This is our best and final offer. A 5% increase plus improved health benefits. By calling it a BAFO, the employer signals that negotiations are almost over. It's a psychological tool. Either accept this or risk collapse. Professional context you'll see. The government issued a best and final offer to bidders. Or counsel advised the client not to present their BAFO too early. The union threatened to strike unless the final offer was improved. For lawyers, the phrase carries a strategic weight. Declaring a BAFO too soon can backfire. because it removes flexibility. But at the right moment, it can break a stalemate by putting maximum pressure on the other side. It's a phrase every negotiator must handle with care. Finality can bring resolution, but also risk. In high level negotiations, both sides often claim they've reached their limit, but experienced lawyers know to ask, is there still room for maneuver? Imagine a construction dispute. The contractor insists on payment within 30 days. The developer insists on 90. Both say no more concessions. But the mediator probes. Do you have any room for maneuver on the payment period? After some hesitation, the contractor admits, perhaps 45 days if interest is added. Suddenly, the deadlock loosens. Why is this phrase important? Because it separates absolute limits from negotiation limits. Lawyers who identify room for maneuver can craft compromises without making their clients appear weak. Common contexts you'll hear are the board authorized limited room for maneuver on price. Counsel confirmed there was no room for maneuver regarding liability. The mediator explored whether the parties had left themselves room for maneuver. This phrase is especially useful in international negotiations where face saving is essential. It lets parties signal hidden flexibility without openly admitting it. In advanced legal English, room for maneuver is a professional way to talk about flexibility, more precise than simply saying options or compromise. Let's look at a story to wrap it up. In a recent cross-border commercial dispute, two technology firms were negotiating a licensing deal. The talks froze when the parties hit a stalemate. The licensor demanded high royalties. The licensee insisted the fee was unsustainable. Neither side would move. The mediator reminded them that the discussion was without prejudice, encouraging frank dialogue. Counsel for the licensee then introduced an exploratory proposal. What if, instead of a fixed fee, we agreed on a percentage of sales? The licensor rejected it at first, but instead of closing the door, they offered a counterproposal. We could accept a lower percentage if there's a guaranteed minimum payment. At this point, the mediator reframed the options using comparatives. This structure is less risky than litigation and a better alternative than prolonging the impasse. When progress stalled again, the parties agreed to a provisional agreement. They would exchange data for 60 days while negotiations continued. This created breathing space and trust. Finally, the licensor presented a best and final offer, saying, we will accept 5% of sales with a guaranteed $1 million annual minimum. That is our final position. The licensee considered whether there was still room for maneuver, and after internal consultation, accepted the baffle. The result, the deadlock was broken, not by force, but by language. Through vocabulary, grammar, and precise legal phrasing, the negotiators kept the dialogue alive, created alternatives, and guided the parties to resolution. Let's review what we covered today. You expanded your negotiation vocabulary, learning professional terms that describe stalled talks and strategies for progress. Stalemate, fallback position, counterproposal, trade-off, provisional agreement, MOU, framework agreement, and binding term sheet. You practiced advanced grammar tools that make your proposals persuasive, using emphatic modals to show certainty or impossibility, must have or can't possibly. Also, framing alternatives with comparisons. For example, a better option would be, or less risky than. Also, using the formal subjunctive to make professional recommendations. We suggest that. It is essential that. You also work with legal phrases that lawyers and mediators rely on. Without prejudice discussions to protect negotiations, exploratory proposals to test reactions, best and final offer, BAFO, to set clear limits, room for maneuver to identify hidden flexibility. And finally, you saw how all of these fit together in a realistic negotiation story, where careful language, not confrontation, unlocked a stalled licensing deal. This lesson shows that in advanced legal English, breaking a deadlock is not just about strategy. It's about how you frame the language. With the right words, you can move forward even the most difficult negotiations.